Contented Media presents Dr. Bitcoin, the man who wasn't Satoshi Nakamoto, an original podcast series with Mark Hunter and Arthur Van Pelt.
Hello and welcome to Dr. Bitcoin, the man who wasn't Satoshi Nakamoto, and part 2 of our COPA vs Craig Wright special series. In part 1, we covered the genesis of the case and saw how Craig Wright's cease and desist letters over the Bitcoin white paper backfired massively and led to COPA suing him after he refused to prove his Satoshi credentials to back up his claim. Part 2 will see us get into the critical shaping of the trial, and joining me at the potter's wheel, but not like that scene in Ghost, is Arthur Van Pelt. Arthur, we start to get into some of the meatier chunks in the case now, and this is where we start to see the tide turn against Craig Wright, isn't it?
Yeah, absolutely, Mark. And you know, we are lucky because in England, they don't have a court docket system like in the United States. So normally we wouldn't know from week to week what is happening in lawsuits in England. Yeah, unless you are a lawyer and you have a bag of money, you can request all those filings from court, and you have to pay for them quite heftily, is probably the word. The Bitcoin developers, they have been involved with the COPA case. What they do, they have their own website and they post regularly the filings and the orders of the COPA case. And oh boy, they are good.
They certainly are. Well, shall we crack on with part 2?
Yes, sir.
We left part 1 in June 2023, with Craig Wright promising irrefutable evidence over his Satoshi claim, something that any rational person might think should have probably been produced before now. Wright's claims perpetuated the idea that he had, for some reason, held back evidence specifically for the COPA case, as one genius on Twitter opined. Quote, "The strategy seems to be to win the smaller cases using existing lower quality evidence so as to lure in the big fish and then use new high quality evidence to win the big cases. COPA is about as big as it gets." Unquote. If this was the theory, then it hadn't worked. Wright lost against Peter McCormack and Hodlonaut and let all his other libel cases, bar his case against Roger Ver, lapse after filing them. By the time of Wright's irrefutable evidence tweet, the evidence-gathering process was well and truly underway. A September 2022 case management meeting, delayed by 3 months after the Deputy Master was asked by COPA to recuse himself, had brought some clarification on evidence submissions. Wright was given until February 28, 2023 to provide COPA with, quote, "a list of documents upon which he primarily relies in relation to the factual issue of whether or not he is the author of the Bitcoin white paper," unquote. Evidence that had apparently been sitting at the bottom of a drawer and which had been discovered in the 15 months since the evidentiary deadline for the Hodlonaut trial. In fact, Wright submitted his evidence far earlier, in November 2022, where it was sent off to digital forensics expert Patrick Madden for his analysis. In the meantime, COPA's lawyers combed through Wright's submissions and worked out which ones it wanted to establish a chain of custody for, with Wright allowed until the end of April 2023 to provide this chain of custody. Arthur, why was this important?
Well, you know, a chain of custody, and in a legal sense we mean here, is a chronological documentation or a paper trail that records the sequence of custody of a piece of evidence. And it means that the provider of that chain, which is Craig Wright of course, he cannot come up with lame excuses afterwards that he had no idea which piece of evidence came from where, or that other people had it in their custody when actually he had it under his own custody all this while. So he cannot come up with those type of lame excuses anymore. With each piece of evidence, and especially the more important pieces of evidence, the reliance documents, I think they call them in the COPA case, when they know from the start till the end where this evidence has been hanging out, let's call it like that, that makes it very important because, again, Craig cannot hide behind any excuses anymore when they know that something has been in his custody from the start till the end. And when they find out that it is a forgery, then who is to blame? Craig Wright himself.
Well, the problem he's got is that he changes his mind on things so often that he's only got one chance to give a story across.
Yes.
And if they find any holes in that story, he can't then change it, can he? Because he said this is where it came from. He can't change his mind afterwards when they find holes in it.
Oh, yeah, he can, and he can try, but that will not be taken lightly by the judge, of course.
Mm-hmm. The September 2022 order also discussed 3 other key issues. The first referred to a technical primer on Bitcoin, which would ensure that both parties were discussing the same thing when it came to the cryptocurrency. This was important given Wright's claims that BSV is Bitcoin, with the master clerk ruling that if the two sides couldn't come to an agreement over how to define Bitcoin at trial, they could produce experts and the judge would rule on the matter beforehand. The hearing also tackled Wright's autism claims, with the master clerk ruling that Wright would be allowed to produce expert testimony as to how his autism might negatively impact him at trial, while it was also decided that all talk of the MIT license issue would only go as far as the uploading of the Bitcoin white paper and not into the realms of copyright, which was reserved for the copyright cases. In June 2023, with Patrick Madden preparing his report on Wright's evidence, something very important happened at Wright's instigation. Arthur, what was this extremely important event?
They never call him the judge, but Justice Meller. What he did, he took 4 running cases with Craig Wright involved, and it means all the cases except the pineapple hack or fiduciary duties case, because in that case it's not important if Craig Wright is Satoshi or not, so he took all the other cases, and then he ruled that 3 of them could be halted and 1 could continue under the label the identity issue. Then what happens if Craig wins on the identity issue, which is the COPA case then the other UK lawsuits that he had started, which includes the passing off cases and the copyright cases, they can continue. And if they do go ahead, the defendants are not allowed to say that Craig isn't Satoshi anymore, because it was ruled in the COPA case that he is. But if he loses the identity issue, then those cases are immediately dead. So the COPA case has now become the main case with the most important umbrella issue over all these cases, and that is Craig Wright Satoshi Nakamoto or not?
With the fate of 4 other cases and potentially more down the line now resting on the outcome of the COPA trial, the stakes were raised higher than an abattoir on a mountain. Interestingly, neither Craig Wright nor Calvin Ayre mentioned this ruling on social media, with the issue taken in a fairly neutered manner by the BSV collective. Perhaps they too realised what was at stake now. We did, however, get a repeat of the Peter McCormack argument on Reddit. Quote, "I wouldn't be surprised if COPA drops the case so that Craig won't be able to present his evidence and witnesses." Unquote. For those who've forgotten or may not know, Peter McCormack was accused of running scared after Wright presented, quote, "a crazy amount of evidence," unquote, which Wright supporters say was behind McCormack dropping his truth defence. This, as some may remember, wasn't the case at all, with McCormack unable to afford the millions of pounds it would have cost to tackle it, hence why he dropped it. The following month, the evidentiary timetable was revised, and with good reason. In late June, Ontier was ditched from every Craig Wright case, with a new firm, Travers Smith, described by CoinGeek as heavy hitters, taking up the hot seat. Because of this change, Wright asked for a 4-week delay in the filing of his witness statement, something that Justice Meller was not too happy with. Quote, "It is true, as various of the defendants have pointed out, there is very little reasoning, other than his assertion that he needs 4 additional weeks. Dr. Wright has known since last September about the deadline for witness statements falling on 7th of July 2023, and I have been given no explanation at all as to how far his previous firm of solicitors got in preparation of his witness evidence." Unquote. In the interests of fairness, however, Justice Meller granted Wright 3 weeks extra time to file his witness statements, which were now due on July 28th. This had a knock-on effect for everything else. COPA would supply its expert review of Wright's evidence on August 25th, with Wright's expert evidence due in return on October 6th, with oral arguments to come in the weeks after. Justice Meller also made a pointed reference regarding the technical primer issue. Quote, "Dr. Wright's team did not engage with the technical primer, they simply put forward a glossary of terms. Mr. Greenberg, Wright's lead counsel, has heard what I had to say about the lack of cooperation here, and it's to be hoped that there will be a better engagement on agreeing a technical primer." Unquote. Justice Mellor's final order of business was the issue of skeleton arguments for both sides. Wright had proposed an exchange on the 18th of December 2023, whereas COPA wanted the arguments exchanged 1 week before trial, in the first week of January. Arthur, why did COPA want to wait so long to share their planned arguments with Wright's team?
I have to guess here for a bit, because I'm of course not sitting in their boardrooms where they make these decisions. But we have a quote from the ruling which probably helps explain it.
Mm-hmm.
He, which is COPA's lawyer, also made the point that he did not want to telegraph all of COPA's points to Dr. Wright in view of the fact, as he submitted, that Dr. Wright has form for changing his story, bringing forth new documents. And he made reference to the judgment of Justice Chamberlain in previous litigation involving Dr. Wright. I think it has to do with this strategy that they don't want to spill the beans too soon, so Craig Wright has little to no chance to prepare for what's coming at him. And this is, of course, as we understand from the quote, completely understandable. The truth never ever needs any preparation, normally. There's only one truth, if you ask me, and Craig Wright should be able to tell and explain that one truth in one unprepared go.
Mm-hmm.
So to trap Craig Wright in as many untruths as possible, Craig should not be able to know what questions are going to be asked, so to say.
Justice Mellor wasn't buying this, however, saying, quote, "I'm not sure I find the point about not wanting to telegraph COPA's points to Dr. Wright very persuasive, because, after all, that is precisely what opening skeletons are designed to do," unquote. He also added that he was not persuaded by the reference to Wright's conduct at previous trials and warned, quote, "Suffice to say that if Dr. Wright's story changes materially at the last minute, that may not bode well for his prospects at the COPA trial," unquote. The skeleton arguments, Justice Mellor ruled, would be exchanged a week before the trial, around January 7th, 2024, as COPA had requested, but only due to the compressed timetable they were now working to, which, of course, was down to Wright asking for his extension. Wright and COPA exchanged their first witness statements on July 28th, and in September, Justice Mellor ruled on several matters ahead of a 3-day hearing due to take place later that month, with another ruling to follow on October the 3rd. For the sake of brevity, we'll tackle these together. The rulings chiefly revolved around two areas: COPA's complaints that Wright wasn't playing ball over basic information gathering, and Wright's attempt to get what he called hearsay evidence prevented from being heard. First, the COPA side. COPA had served 3 requests for information, RFIs, on Wright since 2021, with the latest, a consolidated RFI, coming in June 2023 and demanding that Wright answer a series of questions as part of his July 28th witness statement. These RFIs sought answers regarding Wright's alleged creation of the Bitcoin white paper, the 2016 signing sessions, the Tulip Trust, and more, with COPA claiming that it needed these answers in order to properly direct its actions at trial rather than waiting until trial to find out. Wright, in COPA's view, had failed to answer any of the RFIs properly, ending with practically no questions answered in the most recent one. Arthur, this all sounds a little familiar.
Yeah, doesn't it? I mean, Craig Wright often blames his opponents to try delay things or to be convoluted and unclear, but it's actually even more often that Craig Wright himself is delaying and is being unclear. And that's what we saw happen, for example, in the Kleiman case, when it came to the Tulip Trust list, or when he had to come up with this form 1977, which was that form that maps out someone's assets, bank accounts and things, so that the debt collector gets a detailed idea where to look when it comes to debt collecting. Now, and of course we know that in public, Craig always uses these big words about how he's richer than some countries in Africa and that he owns super expensive watches and fancy cars. But that 1977 form was practically empty.
Wright's argument against answering the RFIs was that COPA should wait to see his evidence before asking the questions, but COPA called this a delaying tactic and, on 14th of July, had asked Justice Mellor to force Wright to answer them. Following a hearing over the matter, Justice Mellor had tackled the various topics within the RFIs individually in his July ruling, but noted 3 things at the outset. Firstly, that the questions were on matters that, quote, should be within the knowledge of Dr. Wright, unquote. Secondly, that they went, quote, directly to pleaded issues and many of the most important documents in the case, unquote, and thirdly, which I'll quote in full, A. These are questions which Dr. Wright has had for at least 3 months, and in many cases for much longer. B. The trial will determine the identity issue for a case which Dr. Wright's previous lawyers boasted, on their own website, was the most valuable ever launched in the English courts. And C. As the court is aware from other claims before it, Dr. Wright is seeking to establish wide-reaching IP rights based on his claim to be Satoshi. Unquote. When it came to the Bitcoin white paper, Justice Mellor noted that Wright had, quote, disclosed at least 9 documents which appeared to be drafts of the white paper, unquote, but had not said in which order they were drafted or which versions were shared with whom. Wright's rationale for this, given during other trials, is that he worked on multiple versions at the same time. Justice Mellor noted that, quote, Dr. Wright's evidence on these topics will need to be carefully explored, since he has given inconsistent accounts on these matters in the past. Furthermore, these drafts and their metadata have been analysed by COPA's expert, who has found many indicia of tampering, alterations and inconsistencies in these various versions. Unquote. Another of COPA's questions was to do with the 2016 signing sessions. Quote, requests 19 and 20 require Dr. Wright to specify the precise technical means he used to demonstrate, in each of the 4 interviews, his possession of the private keys for blocks 9 and 1. Request 21 asks for the same information in relation to block 11, but also to whom, how and when Dr. Wright demonstrated his ability to sign a message on block 11. In his initial response, Dr. Wright referred to certain paragraphs in his witness statement. COPA submitted those paragraphs did not provide sufficient answers, and I agree, unquote. Arthur, this element of the case has given rise to a suggestion that Craig Wright is going to be forced to sign a block in court. But they're forgetting one thing. He stomped on the hard drive holding the keys. So they're going to be bang out of luck.
Yeah, that's what we learned in Norway, didn't we? Yeah, they in Norway, that was in September 2022, during the Hoddelnot trial in Oslo. At some point, Craig Wright admitted that he stomped on the hard drive containing the private keys, or containing access information to the encrypted, or wasn't it the Show Me Your Secret scheme thing where the private keys were put in? But anyway, Craig's stomping created a few media headlines again. But yeah, let's be very realistic here, Mark. I have not come across anything that tells me that Craig either offered to sign or that the judge ruled that Craig should sign. If I'm honest with you, Mark, if I were the judge in the COPA case, I would have ordered sign in front of me, please. Now, or during the trial then, of course. And what also surprised me, or I must have missed it, it could be, but I found it also a bit of a surprise that also COPA has not requested, as far as I know, that Craig Wright should assign, for example, the Genesis block in the courtroom. So it won't happen now, I'm afraid.
Justice Mellor also cast doubt on a key aspect of Wright's signing session farce, noting, quote, these requests relate to Dr. Wright's claim that he allegedly obtained a hard drive which gave him access to, at least some, private keys used for the signing sessions before they took place, but then bizarrely decided to destroy the hard drive afterwards, unquote. Arthur, what was Wright's reasoning for not answering questions over the signing sessions?
Yeah, that's what we indirectly learned from the Justice Mellor ruling, because he said, Dr. Wright suggests that these questions are disproportionate and are an attempt at cross-examination on paper, and both objections are nonsensical. The questions are open, factual questions aimed at understanding his case, and he should be able to answer them with no real effort. And this is funny, because in so many situations on social media and in, well, let's say friendly interviews, Craig is offering unsolicited and almost always entirely wrong takes on Bitcoin, legal matters and things like that. And yet when someone actually challenges him on what he is saying, what does he say? Yeah, you shouldn't be asking these questions. And what's the first rule of a cult? You don't ask questions.
That's true.
Yeah.
COPA also wanted to know details about the deed of trust, which, again, Justice Mellor said Wright should be able to answer without much trouble, and also agreed that Wright should tell COPA the order of his Bitcoin software releases, noting that this information in particular was, quote, critical to addressing that case, unquote. The rulings also addressed Wright's alleged autism spectrum disorder, ASD, which, let's not forget, was supposedly diagnosed during the Kleiman trial, although, as it turned out, it wasn't a formal diagnosis as it was done remotely. Wright's camp claimed that his ASD affected the way he answered questions, although Justice Mellor noted that, quote, he has given evidence without any evident difficulty in at least 3 previous trials and without anything like the level of adjustments now sought. In McCormack, he had just a pen and paper in the witness box. Justice Mellor added that in this and other cases, Wright, quote, handled complex questions without apparent difficulty and showed himself capable of direct answers, although he sometimes gave long and digressive responses. In McCormack, Dr. Wright did not seek to have ASD evidence adduced, and he had no obvious difficulty giving evidence before Judge Chamberlain, unquote. He then stated that Wright was, quote, seeking to introduce ASD evidence very late in order to obtain extreme adjustments which would neuter cross-examination and seriously impair proper testing of his claims, unquote. Arthur, what were these adjustments he was seeking?
There was this guy called Klin during the Kleiman case, but apparently Klin wasn't enough or not good enough for the COPA case, and so COPA says he went expert shopping, and he found a guy called Professor Fasel. And this professor diagnosed Craig Wright again with ASD, and he said the condition can cause Dr. Wright to come across as rude and obstructive, and that he may misunderstand questions. Well, so yeah, now this is ironic, Mark, because how many times in the Kleiman case especially did Craig correct tiny details that the prosecutor might have got wrong. There was no sign of Craig misunderstanding questions there. More often than not, he corrected the questioner.
Oh, over and over again, yeah.
Yeah, exactly. Professor Fasel suggests a remarkable series of changes to the trial process, notably 1. That Dr. Wright is given cross-examination questions in writing. 2. That follow-up questions are short without conditionality. And 3. That there should be breaks every 30 minutes. He also suggests considering Dr. Wright being provided with cross-examination topics in advance.
You're joking.
Yeah, this is quite something. We have to see if that is honored.
Understandably, COPA balked at such suggestions, saying that the changes would prejudice their case and would, quote, seriously disrupt the timetable and the preparations for trial by the parties and the court, unquote. It also noted that Professor Fasel had never seen Craig Wright answer questions in court before, and so couldn't form an opinion on this aspect. COPA also claimed that the court should simply, quote, consider and take account of Dr. Wright's claimed condition, unquote, asking him to produce a diagnostic letter and let the court decide on adjustments. Justice Mellor sided with COPA, agreeing with its assessment of the situation and requesting a written diagnosis of Wright's condition from which he would decide on adjustments. Overall, Justice Mellor ruled that COPA, quote, must be allowed to test Dr. Wright's case by pinning him down on key issues in circumstances where his own statement is strikingly vague in many important respects, unquote. Wright had his chance to get at least one punch in when it came to the RFI fight, tackling COPA over the Bitcoin primer. Arthur, tell us about this one.
Craig is currently of the stance that there is a Bitcoin pre-SegWit activation and there is a Bitcoin post-SegWit activation. The Bitcoiners who are around for a while and know a bit of Bitcoin history, that this happened in August 2017. Now, and that stance fits in with Craig's story that Bitcoin with the ticker BTC is no longer the true Bitcoin. Surprise, surprise though, Craig got it all wrong, which we learn from what Justice Mellor said. The RFI, request for information, does not meet the standard of requesting information which is reasonably necessary and proportionate for Dr. Wright to prepare his case or understand the case he must meet.
Couldn't even get that right.
Yeah. So COPA had 60-something questions and the judge found no issues with them. Craig just didn't want to answer them, okay. And Craig had the chance to get COPA to answer just one of his questions and he totally blew it. Yeah.
Yes, he did.
Now, we also got a note from the judge, Justice Meller, on the Bitcoin primer discussions. He said that conversations over an agreed primer had completely broken down, and we learned why. COPA said that Dr. Wright insisted on including contentious material over the definition of Bitcoin. This, of course, is no surprise, but it's pretty telling that he didn't even engage with COPA and prefers to allow the judge to decide what Bitcoin is before the trial. And it's clear to me that he thinks that the judge will rule completely his way and say that BSV is Bitcoin. But if you ask me, in my opinion, Craig's in for a bit of a shock here.
Wright was told by Justice Meller to answer COPA's questions on the writing of the Bitcoin white paper, the 2016 signing sessions, the Tulip Trust and its private keys, Bitcoin source code, the Satoshi life story deal, and more, the equivalent of 67 of COPA's RFI questions. He was given until 9th of October to provide answers to the block signing and private key ownership questions, and until the 23rd of October to answer the remainder of the 66 questions that had been taken from the various RFIs and lumped into one. The second area discussed in the hearings was Wright's attempts to get certain hearsay evidence rejected, namely the forensic document reports of Dr. Edman from the Kleinman trial and KPMG from the Hoddernaut trial. Wright argued that the inclusion of the evidence would, quote, disrupt the procedural timetable and be unfair to him in that his document forensics expert would need to address further documents, unquote. That they covered the same ground as the reports already included in evidence, and that Wright's counsel might have to apply to cross-examine the authors if they were allowed in. Justice Meller noted that, quote, none of the objections from Dr. Wright lead to the exclusion of these two reports, unquote, noting that, quote, in many cases, the opposing party's experts found the documents to have been altered or tampered with, often apparently altered with a view to supporting Dr. Wright's claims. Dr. Wright's own experts did not dispute many of those findings, unquote. But Arthur, what was Justice Meller's final ruling on this?
Yeah, well, he didn't allow the Kleinman reports from Dr. Edman and also not the Hoddernaut KPMG report. And to be honest, his reasons actually make sense. I understand what he's saying, and I have no issues with the fact that Craig Wright sometimes also wins a little court battle too. He actually listed 8 reasons why the evidence couldn't be allowed in, and here are the most important ones. The content, for example, in the reports was wholly duplicative of what was already in the Madden report. Allowing the reports would have added unnecessary costs and would have led to practical difficulties, for example, cross-correlating the evidence between the reports and whether having another 7 expert reports would help or in fact hinder the judge. So in the end he ruled, accordingly, I allow Dr. Wright's application to exclude COPA's second amended hearsay notice relating to the expert reports of Dr. Edman and KPMG.
I mean, that would have been bad if they contained stuff that wasn't in the Madden report, but it seems that it's pretty much all there anyway. So really, Craig Wright may have won that, but it's not really a loss for COPA, is it? The evidence still gets analysed and still goes in.
Yeah, exactly. And the funny thing is, by bringing the subject up, COPA is, of course, presenting this stuff to the judge, and he has been thinking about it, he has been reading about it, and he will, of course, keep in mind during the trial, oh yeah, this was a piece of evidence that is not only in the Madden report, but was also in the KPMG report, and probably also in the Kleinman case, and they will probably not even delete that stuff. It means that the judge will... how do you say that?
It'll be in the back of his mind.
Yeah, but it will be so clear for the judge that not only in this case, also in other cases, Craig Wright is filing a lot of forgeries.
CoinGeek heralded the ruling as a win, making the most of Justice Meller calling COPA's claim that Wright wouldn't be harmed by the inclusion of the 2 reports disingenuous, but had to admit, way down in the article, that Wright needed to answer lots of COPA's questions that he had tried hard to avoid. The filing also gave us an insight into the makeup of Wright's evidence, with Justice Meller noting, quote, this body of disclosure includes many documents which appear to be drafts of the white paper, unquote. Let's not forget that, up until Wright's evidence submission, he had only ever produced about 5 draft white papers, all of which were debunked by KPMG in the Hoddernaut trial, and yet here we learn that the body of Wright's massive evidence haul was Bitcoin white paper drafts, just in time for a case directly related to the Bitcoin white paper. What a lucky find. Where, though, had these white paper drafts sprung from? On October 3rd, Kurt Wright Jr. said the following during his weekly show for CoinGeek, which, for those who aren't aware, is called Don't Know Next Question.
Like I said, if Craig is Satoshi and is an expert in deleting information and then deleted all the information, destroyed the information that proves he's Satoshi, that puts him in a weird position for proving he's Satoshi now because, sorry, that stuff's gone. Best case scenario, he finds an old hard drive that he forgot about, gets it properly imaged, and then it becomes, hey, here's a draft of the white paper from a hard drive that hasn't been touched since 2006.
Almost a month before this, on September the 5th, Craig Wright had just so happened to send a text message to nChain CEO Christian Hansen, which included references to an encrypted drive and 4 million pages of evidence. What are the chances? Wright's bold claims over his evidence continued into the 20th of September in an email to Hansen, where he claimed to have discovered yet more evidence down the back of his couch, including Vistamail receipts, the original 2002 Project Blacknet filing, and 4 million words written about Bitcoin between 2005 and 2007. Wright claimed that this was enough evidence to, quote, prove that I'm Satoshi at least 100 times over, unquote. This message came some 10 months after Wright had already submitted his evidence for the COPA trial. But Arthur, why is Craig Wright protesting so hard to Christian Hansen about his evidence at this particular point in time?
Well, because Christian Hansen had already started to question the validity of the evidence that Craig was presenting to him. You might remember that report that Christian promised to bring out that never arrived, but now we know why.
Yeah.
So he is already suspicious about what he has seen from Craig's side, and he is starting to see big cracks in Craig's story. And we have to think that between September the 5th and September the 20th, that Christian is asking Craig for more evidence.
Mm-hmm. It's also worth noting that Craig Wright referenced the Project Blacknet paper to Christian Hansen as proof of his Satoshi claims, despite Justice Meller having this to say about it the previous year. Quote, Dr. Wright does not, as the case is currently pleaded, appear to be asserting in his action that anything to do with Project Blacknet directly proves he is Satoshi, only that it was an early contributor to the ideas which eventually became Bitcoin. Au contraire. Hansen revealed that Wright had in fact magically discovered 5 hard drives from a crucial time period, right when new evidence was so badly needed. The contents of these drives were sent to COPA and, as Kurt Wright had predicted, precipitated the disclosure of more smoking guns than a Civil War battle reenactment. Or not. During the September hearings, it was revealed that Wright had submitted over 4,000 documents from his recovered drives as evidence, all of which were sent to Patrick Madden for analysis, who had produced a report which had been sent to Wright on September the 1st. Arthur, these September filings represent our first exposure to something that's going to be centre stage of the COPA trial, the Madden report. What do we learn about it at this early stage?
Yeah, we already learn here about a few nice details. They are providing a firm glimpse already of what we can expect of the forensic inquiry that COPA, or Patrick Madden on behalf of COPA in this case, had performed. We learned, for example, that Craig Wright had served 8 witness statements and COPA had served 13, as well as the Madden report, which, and I quote from the filing, concludes that a large proportion of Dr. Wright's reliance documents and many other documents in his disclosure set have been altered, often with the apparent purpose of supporting his claims. Oops. We also learned, amazingly, that the report was over 900 pages long, including 40 appendices. In actual fact, it ran to 970 pages. So if you print that out, we're talking nearly 5 kilograms of paper, all dedicated to Craig's forgeries.
Brilliant.
And the most amazing thing is that most of it is even new evidence. Where did he find the time to create all that stuff?
News of the 970-page dismantling of Wright's evidence didn't immediately make it into the BSV community, for obvious reasons, and ushered in a period of effective radio silence on the subject of the COPA case from Craig Wright, Stephen Matthews, Calvin Ayre, and others, a period of silence that continues to this day. At the time these reports dropped, however, there was another very good reason why they had gone silent.
So first of all, we have this post here from a CAH, Christian Ager Hansen. He has said, I can confirm I have departed from nChain Global as its group CEO with immediate effect after reporting several serious issues to the board of nChain Group, including what I believe is a conspiracy to defraud nChain shareholders orchestrated by a significant shareholder. I've also reported that I have found compelling evidence that Dr. Craig Wright has manipulated documents with the aim to deceive the court he is Satoshi. I'm today myself convinced that Dr. Craig Wright is not Satoshi, and I'm persuaded he will lose all of his legal battles. Right, well, we will get into this in a minute because that statement is just absolutely ridiculous.
Arthur, we did a whole podcast dedicated to Christian Ager Hansen's departure and the fallout, so we won't go over old ground here. But what were the key takeaways from this event as far as Craig Wright and the COPA case was concerned?
Oh yeah, that was a fallout that was pretty disastrous for Craig, because Christian Ager Hansen accused Craig of faking his Satoshi evidence, and he said that Stephen Matthews also lost all faith with him, despite supporting him since 2015. And Christian says that both he and Craig were sacked from nChain just 2 days after Kelvin wrote a long email to Craig Wright, which was pretty damaging for Craig. And I have to be careful what I say here, but the email shows Kelvin also saying that he thinks Craig is going to lose the COPA case if he doesn't sign a block, where we learn of a Harvard signing for the first time. And Kelvin warns that all Craig's intellectual property might disappear. We know that Christian is in legal trouble for revealing these details currently, so I will leave it here at the moment. We've always wondered what Kelvin really thinks of Craig's claims, and this email shows that Kelvin privately has a lot of reservations, despite what he says in public.
Also, there's a great photo, I think a lot of us have seen, of Stephen Matthews and another lady sitting behind a desk in a deserted office looking quite pensive. What's the context here? You know the one I mean?
Yeah. I think it is deleted now already from Twitter, because Christian deleted quite a lot of stuff. That was the time when Christian Ager Hansen, he organized a mock practice trial to prepare for the COPA trial. I'm going to quote from an article that I translated from Norwegian. It was published in DN Magasinet under the title, I have been in many wars, but nothing has been like this. If I'm right, I believe it's my second most read article of this year. Anyway, that little chapter is called Massive Liar.
Subtle.
Yeah, it sets the tone for what is following. Okay, again, this is from the Norwegian article. In offices at 7 and 8 Marketplace, just a stone's throw from Oxford Street, a so-called war room had been set up in the deepest secrecy. A special session was prepared here on the September of 22 this autumn. This was dry training for the big trial against the California billionaires. Now Craig Wright was to be tested on whether he was really Satoshi Nakamoto, but in a controlled setting. According to Ager Hansen, the real aim was to pulverize Wright's explanation. One hired counsel grilled Wright, while another defended the evidence. Wright responded with a story he has told many times before in various court cases around the world, the story of how he created Bitcoin, how he was horrified by how the technology was being used, and that he deleted important evidence before changing his mind. Now remember, Mark, a little break here, that the whole point of this was to answer the simple question, is Craig Wright Satoshi Nakamoto? Mm-hmm. So they have this mock trial where the grilling of Craig Wright was exceedingly powerfully presented, and 2 days later the law firm that they hired sends through their findings, and those findings were, there is only one reasonable conclusion that I can come to. It is that Dr. Wright is a massive liar. Now, so Christian learns here of this epic failure, and he is finally convinced that Craig Wright is never in a million years going to beat COPA with his bullshit evidence. So he tells the nChain board, and 3 days later, both of them are gone from nChain.
Mm-hmm. The revelation about Wright's dodgy evidence led to one of Wright's fans on Reddit attempting an energetic bout of backtracking. Quote, we must remember that what happens in Craig's mind may not correspond with reality. He says his evidence is irrefutable, but he often gets overconfident or thinks he is right and the judge is wrong. He might think it is irrefutable, but most things can be refuted." Unquote. As, indeed, they would be. Arthur, we're going to leave part 2 there with the now infamous Madden report just around the corner. In part 3, we'll discuss what happened when the Madden report landed, as well as the fallout from the N-Chain drama, and an early December pre-trial hearing, the first since Wright had, supposedly, responded to that bumper RFI. Something that's worth noting here, though, in the time period we've just covered, which is September 2022 to September 2023, it's notable how all the bullish rhetoric from the likes of Calvin Ayre, Stephen Matthews and Craig Wright himself has totally dried up. In 2021, you had Calvin Ayre telling everyone that Craig Wright was over the moon with the lawsuit, he had the champagne out and it was a gift from God, this sort of thing. But once they actually tried to back up their words with actions, it's just been crickets, hasn't it?
Maybe not exactly crickets, but they've certainly been saying much less than they did a couple of years ago, that's for sure. This might be because the lawyers have told them to shut up, but also it may not be a coincidence that they have stopped talking since they saw the Madden report. But yeah, all this talk of irrefutable proof and Calvin Ayre saying that Craig had the champagne already open, I think that one is back in the wine cellar now.
Oh yes, without doubt. Well, that's everything for part 2. Arthur, thank you so much again, as usual, for your wisdom and your insight, and I will see you again for part 3.
Yep. Looking forward again, Mark. See you for part 3.
Yep, see you then.
Cheers.
Thank you for listening to this episode of Dr. Bitcoin, the man who wasn't Satoshi Nakamoto. Don't forget to subscribe to the show on your podcast platform of choice to get these episodes the moment they drop, and if you enjoyed what you heard, we'd really appreciate a star rating and even a review to help us get this out to as many people as possible. Our monthly bonus episodes are available to download from our website for a small consideration, and if you'd like to access all these bonus episodes, plus these monthly updates a few days early and other goodies, you can do so by becoming a Dr. Bitcoin supporter. See the details in the show notes for information on how to do this, or head to our website drbitcoinpod.com. That's drbitcoinpod.com. You can also follow us on Twitter at drbitcoinpod, and you can email us at drbitcoinpod@gmail.com. That's drbitcoinpod@gmail.com. Thanks very much for listening, and we'll speak to you again soon.
You've been listening to Dr. Bitcoin, the man who wasn't Satoshi Nakamoto. Written by Mark Hunter, with additional material by Arthur Van Pelt. Editing and production by Mark Hunter. This has been a Contented Media production.